Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Recording videos over the weekend. You know, you think you're going to be recording things about one thing and you start making notes and all of that stuff, and then all of a sudden a really hot issue pops up. What is the hot issue? Well, it's the Sig P320 once again. Now listen, we already did this video right here where we kind of took a look at the big picture, and now we're going to kind of take a look at a tiny little slice of this dilemma, which is taking place right here in Washington State. Many of you may have already heard this, that the Washington State Criminal Justice Training Commission has banned the Sig P320 at all of their training facilities. It creates a big problem for some law enforcement agencies. It also creates a really big problem for SIG, and they have decided the best way to deal with it is to file a lawsuit against the state of Washington. So what we're going to do today is we're going to go through that suit so that you guys can get educated. So today, let's spend a few minutes and let's talk about SIG sues Washington over their P320. Okay, America, we're going to be talking about the Sig P320 again, but today we're going to be talking about the very strained relationship that the manufacturer now has with the Washington State Criminal Justice Training Commission, which is basically the agency that trains all law enforcement agencies in the state of Washington, with the exception of the Washington State Patrol. Washington State Patrol has its own training academy. So any county sheriff, any municipal police officer, anywhere in the state of Washington has in fact graduated from WSCJTC. Dateline, October 2024, after an incident in which a Sig P320 unintentionally discharged, allegedly, the Washington State Criminal Justice Training Commission suspended the use of the P320 temporarily. However, Dateline, February 2025, the Washington State Criminal Justice Training Commission then permanently bans the use of the P320 on all of their facilities. Now, this is a big deal because many police departments do not have their own firing ranges, and therefore many of them will use WSCJTC's training facility, which is located right down in South King County. Now, this means that law enforcement agencies that have the P320 as their issued sidearm, or some version of it such as the M17 or M18, cannot train on these training facilities anymore. And that has put at least 3 police departments in the state of Washington in a really tough position. And that is the city of Bellevue, the city of Kirkland, and the city of Anacortes. Well, SIG isn't too happy about it either, and they have filed a lawsuit against the state of Washington, in particular, Washington State Criminal Justice Training Commission. The case is actually Sig Sauer Inc. versus Washington State Criminal Justice Training Commission. So Sig Sauer, which is being very bold and brash in their denial of anything being wrong with the P320, and perhaps they're right. Okay, I'm not a firearms expert. I just know that there is a lot of smoke that seems to be surrounding this firearm, which tells me that there usually may be some fire somewhere. But their belief is the best way to handle this issue here in the state of Washington is, in fact, to file suit against the state of Washington. Their complaint starts as follows. Petitioner Sig Sauer Inc. submits this petition for judicial review and declaratory judgment to remedy an improper decision by the executive director of the Washington State Criminal Justice Training Commission to prohibit the current Sig Sauer P320, M17, and M18 firearms from all properties owned or leased by the WSCJTC indefinitely. Now, the lawsuit makes several claims, but it all comes back to the same premise, which is that the executive director, Monica Alexander, had no legal authority and acted outside of any legal authority that she may have had to make this decision. Now, there is an administrative appellate process that SIG could have used. As a matter of fact, they tried to use it. And it appears that the state of Washington was really never getting back to them. And so one of the arguments they make, and they very well may have a very valid claim here, is that, hey, we've exhausted all of the administrative measures that we have. In fact, they're just blowing us off at this point. And for that reason, judicial review is now warranted. And as they put it, the WSCJTC's inaction and simultaneous public interviews by its executive director continuing to disparage and defame Sig Sauer removes any obligations for appealing parties to exhaust administrative remedies. And they're saying, listen, the agency's already acted outside the scope of any statutory authority. Why on God's green earth would we let them review their own actions? Moreover, no administrative exhaustion is necessary, and the Superior Court may take action because the WSCJTC's action is an improper rule. The action goes beyond the scope of the Executive Director's authority and the WSCJTC's rulemaking authority as set forth in Chapter 43.101 of the RCW. Even if the Commission believed it had authority to adopt such a prohibition, it did not follow proper rulemaking processes under the Administrative Procedure Act, Chapter 34.05 of the RCW, to establish such rules. The Commission's action is an improper rule under the APA, and it is subject to direct review by the Superior Court. Okay, all sorts of arguments being thrown here at the state of Washington by Sig Sauer, but they have more. The action violates state law. The Executive Director's unilateral decision is inconsistent with the state's preemption in the field of firearms regulation under Chapter 9.41 of the RCW and does not fall within any statutory exception. So what they're claiming there is that, hey, listen, we got state preemption law, okay, and therefore only the state legislature gets to set the firearm rules. And this executive director is acting as a pseudo legislator in banning these firearms at all of these places. Now, whether or not that is a valid legal argument is going to remain to be seen. We'll talk about the court that they've decided to file suit in, which is good luck with you on that one. But they have more claims. Moreover, the action implicates constitutional rights and at a minimum should be subject to formal rulemaking. The action has the effect of regulating a field constrained in Article 1, Section 24 of the Washington State Constitution. Even if properly promulgated by the state through its police powers, which it was not, regulations must be reasonable and must follow proper formal rulemaking and lawmaking processes. The effect that SIG is claiming that this action by Washington State has on law enforcement in general, which is an important consideration, they claim the following. The action's prohibition jeopardizes law enforcement personnel and operations. Law enforcement departments throughout Washington State trust, rely on, and prefer the P320 as their service pistol of choice. By banning the P320 for new law enforcement recruits, the WSCJTC is putting these men and women at a disadvantage when they need to enter the field and will be assigned the P320. And again, you need to understand that this ban actually does affect more than SIG. And that's the truth, right? Because if you're in the Bellevue Police Department, if you're in the Kirkland Police Department, if you're in the Anacortes Police Department, if you're a new recruit who is about to be hired by one of those departments, you will not be able to use the training facilities and that firearm simultaneously. And that can be a big deal. SIG points out the action has prejudiced or is likely to prejudice Sig Sauer as well as the law enforcement agencies that use the P320, including but not limited to the inability to use or carry the P320 and associated negative impacts related thereto. Moreover, the Commission's improper and unfounded action has caused an imposition of other improper bans by other law enforcement departments and agencies nationwide tied to and based on the Commission's action. So SIG is claiming that because the state of Washington chose to make this decision, many others followed suit. That may or may not be the case, and it may or may not be able to be proven. Now, ultimately, we got a lawsuit. So if we got a lawsuit, what do we need to discuss? That's right, we need to discuss the remedies, because you don't really have a lawsuit unless you're asking for a remedy. So what is Sig Sauer asking the Thurston County Superior Court for? Count 1. Review of agency rule under RCW 34.05.570 sub 2, which is essentially Washington State's Administrative Procedures Act. So they are using the same arguments that were used in the bump stock ban, in the FRT, in the solvent trap arguments and things such as that, where they're basically saying, hey, listen, you are promulgating new rules and you are doing so outside the confines of the APA, therefore the rule itself is null and void. And then SIG is asking for second claim for relief in the alternative for declaratory judgment under RCW 7.24 and RCW 34.05.570 sub 2. And specifically what they are asking for, 1. Setting aside the action prohibiting the current SIG P320, M17, and M18 firearms from all properties owned or leased by the Commission. 2. The entry of an order that reverses the action and allows the current SIG P320, M17, and M18 firearms to be used at all properties owned or leased by the Commission indefinitely 3 in the alternative, in joining and staying the action to protect the rights and interests of Sig Sauer. Also asking for essentially a gag order against the executive, because they're also asking for 4 in joining the commission's executive director from making public statements about the P320 outside the scope of her duties and authority. So, the lawsuit is filed. Now, let's talk about a couple of things. Number 1, what's the likelihood of success? Well, there is a reason that every time someone wants to challenge a gun law in the state of Washington stampedes to Thurston County Superior Court. That's the county in which our state capital lies. Olympia lies inside Thurston County. There's a reason that the state of Washington stampedes into that court to make those arguments. There's also a reason that those that argue on behalf of supporting and or expanding Second Amendment rights avoid the Thurston County Court like the plague. So, venue choice, which really they did not have an option here. Sig Sauer was going to have to file this in Thurston County Court. It would have been removed to it. But I got bad news, and I'm sure Sig's already done their homework here. This is not a particularly good venue. Now, here's the other thing I want you all to be aware of, is that one way or the other, this is going to end in a spectacular fashion for Sig, isn't it? Because when all the dust settles from this fiasco, one of 2 things is going to be proven. Either A, there was nothing wrong with this firearm whatsoever, and it really truly was user error. And then Sig, being so bold and brash and so adamant in their denials, will look like one of the boldest and best business moves ever. However, if there turns out to truly be a defect in this product, and Sig acted and responded in such a bold and brash fashion, denying it every step of the way, filing lawsuits to stop some of the remedial actions that were taken by law enforcement agencies, well, they will have certainly exposed themselves to a far higher level of liability than they originally were. And for many of them, the Sig P320 may become the Ford Pinto of this particular firearm company. And that's a shame, because I think that Sig enjoys a good reputation in the firearm industry, and they enjoy a good reputation because they have earned that reputation. But again, as trial lawyers will tell you, whenever we find this much smoke, it is hard to believe that there is not a fire somewhere. And while I know that Sig continues to claim that this is all user error, I would ask them, why is there so much more user error with this particular firearm than there is with any other firearms, including some that are in much greater circulation than this model? Okay, listen, we're going to go ahead and keep our eyes out on this suit, see if they can actually get something done in Thurston County Superior Court. We're going to go ahead and link up the complaint down below so you don't have to take our word for it. You can geek out on it for yourself. Now, if you got any other questions about this, or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there to tell us all about it. If you want to subscribe to the monthly newsletter, that information's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. And stay safe.